Welcome to the first African Law Seminar. This seminar marks an important milestone in a long journey to provide high-quality international law education for lawyers in Africa. As you may know, the late Ambassador Emmanuel K. Dodsey of Ghana proposed the creation of the United Nations Program of Assistance in the teaching, study, dissemination, and wider appreciation of international law in 1963 to provide high-quality international education for lawyers in developing countries, especially the newly independent states in Africa, Asia Pacific, and Latin America and the Caribbean. At the beginning of the 21st century, I was asked to revitalize the program, to make it more responsive to the needs of the international community for international law training, which had increased significantly since the 1960s. This process took more than a decade and resulted in strengthening the International Law Fellowship Program with the Hague Academy of International Law, which had been the cornerstone and main training activity under the program. As a result of innovative cost-saving measures, the number of fellowships was increased from 16 to 20 persons. This did not come even close to meeting the demand for international training, since we were receiving as many as 500 applications for those 20 fellowships. The next innovation was to designate permanent venues for the 3 United Nations regional courses in international law for Africa, Asia Pacific, and Latin America and the Caribbean, to be held every year rather than every decade. This made it possible to train an additional 30 participants in each course for a total of more than 100 participants per year in the traditional training courses. Thus, the number of African lawyers attending the regional course increased from about 25 per decade to as many as 300 per decade. The final innovation was to establish the United Nations Audiovisual Library of International Law website, to provide international law training and research materials to an unlimited number of persons around the world via the internet. The AVL has been accessed by over 1 million people in every country in the world. The support of Africa was essential to the initial creation of the Program of Assistance and its further expansion, when many people did not support or believe that my proposals had any chance of success, particularly in terms of funding. The African Group of Legal Advisors at the United Nations in New York was instrumental to the success of these initiatives. As you may know, Ghana has served as the chairman of the Advisory Committee on the Program of Assistance since it was established in 1965. This is one of the few United Nations committees that is chaired by the same regional group and indeed the same country, in recognition of the central role that Africa, and in particular Ghana, have played in the establishment and further development of the Program of Assistance. It is my pleasure to note that Ambassador Jane Gazoo and Audrey Abayena of Ghana, who played essential roles in the expansion of the Program of Assistance, are attending the seminar today. We worked with legal advisors from many of your countries to achieve these goals. The African Union Office of the Legal Counsel and the African Union Commission on International Law also provided essential support. The African Union provided funding for the UN Regional Course for Africa when this course was dependent on voluntary contributions. The African Union also adopted a resolution calling on the United Nations to provide regular budget funding for the UN regional courses and the AVL. At a time when the United Nations was facing mandatory budget cuts, the UN General Assembly approved an unprecedented increase of $2 million to promote education for lawyers in developing countries. I had the privilege and pleasure of conducting the UN Regional Course for Africa at the Economic Commission for Africa in Addis Ababa, Ethiopia, from 2011 to 2017. Before my retirement from the United Nations Office of Legal Affairs, after almost 3 decades, the African lawyers who had participated in ARCEL Africa asked me to continue to provide legal materials, and training. The result was the preparation of the 7 volumes of the African Law series, which provides the most comprehensive collection of legal materials adopted by the Organization of African Unity and the African Union. It took more than 5 years to complete the project because many of the legal documents were not readily available, and some are still not available except within the pages of these books. The publications are available free of charge on the African Institute's website. The publications are fully searchable and may be downloaded free of charge. The English version of the African Law Handbook will be updated this year to include recent legal instruments and a new introduction by the AU Legal Council. The French version of the African Law Handbook is currently being prepared and will hopefully be available on the African Institute's website before the end of the year. I am exploring the possibility of providing a collection of legal documents in Arabic in response to requests that I have received over the years. This is particularly challenging because many of the documents are not readily available in Arabic. I note with appreciation the essential support of the African Union Office of the Legal Counsel, and in particular, Professor Hajer Gueldich, in the preparation of these publications. I also note with appreciation the support of the African Institute, and in particular, the program manager, Professor Matthias Sahinkuye, in the preparation of the French version of the African Law Handbook. It is now my great pleasure to introduce our first distinguished lecturer, Professor Hajer Gueldich, the African Union Legal Counsel and Director for Legal Affairs. Before serving in her current position, Professor Gueldich served as a member and president of the African Union Commission on International Law. She also served as a member of President Paul Kagame's team of eminent African personalities for the institutional reform of the African Union. Last year, she represented the African Union before the International Court of Justice during the recent hearing relating to climate change. More recently, she provided legal guidance to the Annual Assembly of Heads of State and Government, which adopted an important new legal instrument that seeks to end violence against women and children in Africa. In addition to her distinguished career with the African Union, she is a full professor at the University of Carthage and has lectured all over the world, including in many of your countries. She has published an extensive collection of scholarly writings on a broad range of topics of international law that are of particular importance for Africa. Hajer, it is my pleasure to give you the floor.
Thank you so much. Really, I appreciate your invitation and many congratulations for you, particularly Professor Virginia, for your commitment for Africa, for African Union law, and for you, Honorable Judge Abdulqawi Yusuf. I know how you are committed to these issues, so this is really, I'm learning all the time. And today you gave me this very nice responsibility to share with our scholars, our invitees, professors, practitioners, this time to comment and to know more about the African Union law, practice and institutions. But again, it is also very interactive, so we will allow the people to make comments and to ask questions, if any. Thank you so much for all your team. Now we are very well with our presentation. I had the challenge to finish it all for today's lectures. It's 88 slides, so let's go to the next one. And if you can see, I will just tackle an introduction to present the origins and the evolution of the concept of Pan-Africanism, because this is the pillar of African Union today. After that, I will just give you an oversight of the history, how we move from the OAU, the Organization of African Unity, to the actual African Union after CERT Declaration 9999. Please, after that, we can go to the part 1 and we will discover together, for the ones who have no idea, the institutions and the main organs of the African Union. So I try to keep it structured. I will begin and tackle the political organs, after that the judicial and the quasi-judicial organs, and maybe an overview of the Peace and Security Council and the architecture of peace and security in Africa, some few words on the REX, the regional community, some few words on AUCL. This is a very important organ. As you said, I had the pleasure and the honor to be member of AUCL, elected member for 8 years, and I was also the chairperson of AUCL, and they are doing a lot in the dissemination and codification of international law. After that, we go through the economic ECOSOC and the financial institution. After the part one, we try to finish it today. Tomorrow, I will just give an overview about the most important illustration of African Union tendencies, or may I say the originality that you can find nowhere in the international law, the positive international law, like the right to intervene in a member state in case of international crimes, like the question of the protection of the IDPs, the internally displaced persons, and the AFCFTA. Please, the next. So I will begin. And maybe we can just tackle some issues on the environment, as I have the pleasure and the honor to represent African Union and its 555 member states in the advisory opinion in front of the court in December 2024 on the climate change and its consequences. And they will have the pleasure also to present the OLC and the African Union this Friday for the advisory opinion. I saw it, and maybe you are how to say, pursuing, and you are connecting to the Palestine case that it begins today in the morning. So as you can see, this is just behind me. This is the African Union headquarters. We are here in Addis Ababa, and we call Addis Ababa as the capital of the African Union and of Africa. And the headquarters of African Union was here because there is a lot of symbolism and symbolic issues behind that. We say that Ethiopia was the only country that was never colonized, even if the parentheses of Italy, but we think that the pride of Africa and also the mana, the Emperor Haile Selassie was one of the beginners and one of the pillars of Pan-Africanism, allow Ethiopia to become the capital of Africa. And this building is 99.99 meters. This is because of CIRT declaration, as I said, 9999, and it is a gift from the Chinese people. Next, please. And just I will comment very quickly on the different pictures before I begin with the political organs. This is again behind me. Just this is the Mandela conference room, and this is where all the summits take place since the beginning of AU activities. And you can see here this pyramid, you know, the podium here, it is done in a way that is pyramidal. In the top, you will find the Commission and the AU Commission plus the presidency of the AU Assembly. After that, you can find the commissioners themselves, and after you can find the organs. And you will notice in all my presentation, I will go with this hierarchy. It is like a pyramidal. So in all the organs, you will find all the time this hierarchy. Next, please. And also in this picture, you can find the very important photo of the summits from one year to another. Next, I will just, this is the statue of Haile Selassie. As I said, is one of the pillars of, and the people who really have done a lot in Pan-Africanism, and it was in 2019. Next, let's go. Please, next, so that we can see the group photo of the summit of this year, 2025. The next one. In 2025, this is the picture of our summit in February 2025. And what is very important to notice this year is that we have election of the new commission, and you can see them in the next slide. In the next slide, you can see here the newly elected president or chairperson of the commission, His Excellency Yusuf from Djibouti, and before him it was His Excellency Moussa Faki from Chad. Next, you can see now the picture of all the new commissioners. plus the DCP, the deputy chairperson, she's from Algeria, and the chairperson of the AU. There are still 2 other commissioners not yet elected. We went through an extraordinary session of the Executive Council, but it was not concluded. So the decision was that we will postpone the election of the 2 remaining commissioners for the next mid-coordination meeting that will take part in July 2025 in Equatorial Guinea. Next. So, well, as I said, it's very important for the ones who need to be familiarized with African Union and institutions, instruments, to go all the time on the website of AU. It is really very well done, and you can find all the materials that you need on the African Union website. Next. Also, we have a very interesting book that is online, and you can find it in French and in English, and you can even put it an icon in your telephone so that you can go through it. This book, it is just a handbook of African Union with all the organs. All what I will tell you today, you can find it in this handbook. This is the last version, 2023, and you can see here that is the theme of the year at that time, 2023. It was about AFCFTA. I also had the privilege to finalize a book, but it is in French. So it's the same. I have courses, and I initiated with professors and other colleagues in University of Tunisia a master's degree on African Union law that was unique in Africa, and we had at least 7-8 promotions of students who were very well interested and implicated with theses and various theses and dissertation on African Union law, organs, instruments. So it was really a very nice dynamic in Tunisia, and they are still continuing with my professors and colleagues. Next. So my book also, you can upload it for the Francophone online. It is free. For the next slide, you can see now, please, next slide. It is not moving. Yeah, next slide. I wanted to focus on the theme of the year. Let's be back. The theme of the year is very interesting. African Union, back please, just 1 second. On the back, the theme of the year, yeah, theme of the year. 2024, the theme of the year was education, back. I didn't begin with the introduction. Yeah, this one. So the theme of the year 2024, and this is also the initiative of Professor Virginia Morris and the team, was to continue on the issues of education. We can know more and disseminate more our instruments, our background, our organs, our Pan-Africanism, our values as Africans by education. And it's very important to rely on the theme of the year, and the whole year, all the things that we are doing in AU are all the time connected to the theme of the year. So the initiative comes from the theme of the year that was on education the last year. This year, 2025, it's really a very interesting topic. The theme of the year is about reparations, justice for Africans and people of African descendant through reparations. And this is also the whole year, all the events, or most of the events, are connected to the theme of the year. Next, now we will go through the introduction. His Excellency Judge Abdulqawi Yusuf wrote a wonderful book, and he offered it to me. It's about Pan-Africanism. And for me, it's a reference for my students. I all the time suggest them to see it and to see and to know more about les pères fondateurs, the people who initiated the Pan-Africanism in Africa through Nkrumah, Senghor, etc. You can have the pictures. And from that, I will move how we switch it from the Organization of African Unity to the African Union. Please, now let's go very quickly because the time is going very fast. The Pan-Africanism didn't begin in Africa. I will be very shocked or surprised. It began in the diaspora, and the first Congress was in London, 1900, and after 1990 in Paris, and after in Manchester. All the idea of the Pan-Africanism didn't begin at all with integration. It is just about please can you go next slide? It is just the issue of racism, discrimination, and the questions of the human being and dignity of the Africans. This was the beginning and the starting of the Pan-Africanism. If you remember the movies that are in black and white, where they say it is forbidden for dogs and blacks, and you can see all the triangle slavery, how these people came from Africa with a lot of torture and a lot of very sad stories. And these people initiated the gospel and all these sad songs, because this is the only manner they can discuss with each other, with songs and with this gospel and all this music. So at that time, after that, I will not go through a lot of details. After, as I said, it will be transformed in another idea. This is the second generation of Pan-Africanism, and it begins at the wave of decolonization. So it goes from the idea of let's be solidaire against discrimination and struggling for human dignity, to another idea. It's about how we can encourage the other African states to have their independence. So there was at that time two ideas: supranationalism. This was the Dr. Nkrumah idea. He's from Ghana. This means that he needs the states of Africa immediately, like the United States of America. So this was a tendency at that time, and they said, we are not ready. There was another idea, Felix Boni and the others, continentalism. And after that, Leonard Senghor, from the president of Senegal, had something in the medium, and he said, let's begin. Number one, to build the continental, the supranationalism, that means the Rex, and after we can go to an African Union and a more united Africa. And this was the tendency. So the third path was merging, and we are in the 1963. Just very quickly, the next slide. We are in the first beginning of how we institute the organization of the African Union. It is again here in Addis Ababa, but it is not in this new building. We have another old building, and you can see, if you go through the YouTube, all the movies or the documentaries that initiated this wonderful speech that when they began the declaration of OAU at this time, is the 1963. And after that, I will just move quickly now. Please go ahead. We move, so you can find also some very symbolic days. 25th of May 1963, this is the day of Africa. However, we have another day, it's the day of African Union. So each 25th of May we celebrate Africa and the Pan-Africanism, because it was the day where the OAU was instituted. Please, next. So how now we go from the idea of the Organization of African Unity to the idea of African Union. I will share with you all this slide just because I have no time to go with details. The idea was just to begin to another organization that should be more strong. And this was the idea of Muammar al-Gaddafi. He was the president of Libya. And that's why in CERT 9999, he tried just to gather the African leaders and to tell them, let's go to another organization, because the organization of the African Unity is not effective and we are not doing a lot for Africans. So let's begin to think about new organs, politically saying Peace and Security Council. Let's begin to think about a new manner to do integration. And now begin another type of philosophy of the Pan-Africanism, and I call that the third generation of Pan-Africanism. This is exactly what are the AU tendency is trying to do with Agenda 2063. It's the idea of integration. Please, next. So that's why the creation of the African Union, here I put in red 55 African Union member states. However, the United Nations and the partners put only 54 because the Republic of Sahrawi is not recognized at the level of the United Nations. That's why they consider only 54 member states. However, for us, African Union, and you can just go to the Constitutive Act and you can see here the ones who signed and ratified. These are the members and the original members who signed the Constitutive Act. After that, South Sudan was divided in two. So we have South Sudan. Sudan was divided in two. We have South Sudan that comes as the 54th, and after Morocco, who just left when AU recognized Republic Sahrawi, and after they choose to come back and become the 55th African Union member state on 2017. Next, please, I just need to underline some issues. Number one, about Agenda 2063. When I ask my students what is Agenda 2063, no one knows. However, it is a whole vision, it's a plan for action. It is how we can, after 100 years from the beginning, I told you 1963, this is the beginning, and the naissance, the birth of AU. After 100 years, the vision is that we are integrated, that we have a prosperous Africa, that we have no conflicts, we are in peace, and we are rich and unified. This is the agenda. And to reach these goals, we need to have a plan. And this plan goes through all the domains. Next, please, you can find all these issues on this just image, so that you can see the aspiration and how they plan for this Agenda 2063 Africa we want. As I said, okay, maybe you can say these are slogans, the population and African population do not feel this. However, at least there is a vision and a mission, and this is also the role of education and everyone. It is not African Union role only. I think all the stakeholders have a role to do that integration. It is a very sophisticated and a very difficult idea, and to be done. This is what I wrote in all this book. I try to say that we need to begin that down top, not top down, and we need to be connected. We need to know each other. We need to delete these frontiers. We need to struggle and to fight terrorism, to fight the immigration, illegal immigration, the gap between the different countries, the problem of corruption. We have a lot of challenges with all of us, we know them. However, at the same time, don't forget that Africa is a very rich continent, that we have the youngest population in the world, that we have a lot to say and to do. So this is also an idea about being together, and this is a whole, I think, plan or construction that is not easy, and it needs that everyone do its responsibility. Next things, it is just some references that can be interesting for you. Article 4, it's about the principles. If you can go through them, you can see that they are exactly the same like the Charter of United Nations, but there is some few originality. Among them, I will tackle that tomorrow, inshallah. The right of the African Union to intervene in the member state when it's about genocide, crimes against humanity, and other international crimes that are the grave circumstances. So next one, you can also see what I just tried to underline, the respect for democratic principles. Can you see this question of human rights, rule of law, good governance? They are very interesting, and they come very late. They didn't begin at the 60s, because the priority of the members states at that time was not the good governance and the democracy. It was to build the new state and the modern state after decades of colonization. That's why I told you they bring a new blood. All these new ideas of third generation of Pan-Africanism is to build another African Union that will be based and have as pillars condemnation and rejection of unconstitutional changement of government like the coup d'etat, and having priority for human rights and rule of law. Again, maybe you can tell me these are just slogans, because in the reality, the challenges are very difficult and very different. However, again, these are the rules. I'm a lawyer, I'm the legal counsel. My Bible is the act, the constitutive act. When I am in the podium and when they ask me for legal opinion, for me, this is my Bible. I see the principles, and after that, all the rules of procedure of the Assembly, of the Executive Council, and of the PRC. These are the rules, and we need all the time to respect the rules. Or when a state or people or whatever do not respect the rules, there should be sanctions. However, because we are not yet in the idea of integration, like European Union, we are not yet with very effective organs in the control of all these issues related to the rule of law. We are still behind. However, again, it's our role to disseminate the backgrounds and also to make some change in our mentality so that the practice can be the same as the rules. Please, next. So the ones who are Article 5, it is about the organs, and this is the article that will allow me to structure my lecture. It's about, in the Article 5, it is not put in classification, but we can classify already. When you see the Assembly, the Executive Council, and the Permanent Representative Committee, this is the pyramid. These are the political organs, plus the Commission. When you see the Parliament, this is also a political organ. When you see the Court of Justice, that is just in the article, but it does not come. After that, we have the Human and People's Rights Court. This is judicial organ. We just have also the Banjul Commission and quasi-judicial organs like the AUCL. After that, we have the ECOSOC and the financial institution. We have a lot of our financial institutions, but it's just they are written, but they are not real till now. And you can see the paragraph 2, it make it open. They said other organs. We are in 1999, don't forget. This came into force in 2002. So today, 2025, we can have new organs. So that's why they put it like open, other organs that the Assembly may decide to establish, you see. So the organs are not only in this list limitative, but we can also allow to do other organs or to initiate other organs. And that's exactly what they said, what they've done with AUCL and with a new organ that was just launched the last week. I was in Egypt as a member of the committee of the Space Agency, African Space Agency. This is also a very interesting and very exciting organ that came like a baby that was born the last week. Please, next. The ones who I said need to be more familiarized, as I said, please go to AU website. It is really very interesting, and you can cover and you can find everything you want. Also, Professor Virginia Morris has a handbook on all the African Union laws and treaties, and also we are doing the same as Office of the Legal Counsel. We have these 2 tomes, and you can have them online for free. These are, but it is just in English. We are now preparing the version in French. So all these volumes are gathering all the treaties of African Union from 1963 till 2014. So this is also very interesting for the ones who need more clarification on the instruments. Now on the organs, I said it's the pyramid. Let's begin very quickly with the political organs. And if I finish my half hour, just tell me. I said these are the organs that are political. I sublined them. Assembly, Executive Council, Permanent Representative Committee, this is the PRC, and the PRC itself, it is composed by 11 specialized technical committees. So this is the pyramid plus the commission plus the parliament. This is what I try to do today for the first section. Next. What is the assembly? The assembly is just the the addition of all the heads of states. So this is the picture I showed you in the beginning, when it's the group photo of the heads of states or the ones who represent them. This is the supreme political and decision-making organ of the African Union. They make the decisions, and you can go through the articles that give you exactly what are the functions of the assembly. So the assembly, it is the sum of 55 heads of states, or they are representative of the 55 member states of African Union. You can see here all the rules and the roles of the assembly. Next, please. This is the picture of the assembly. So all the time in the summit we have as guests His Excellency the Secretary General of the United Nations, always since the beginning of the AU, plus as a honorific guest, the Palestinian Prime Minister or the President. So this is also to pay tribute to the suffer of Palestinians, as in Africa we suffered from apartheid and other issues. This is all the summits begin like that. There is a chairperson of the assembly. After that, the speech of His Excellency the Secretary General of the United Nations. After that, the speech of His Excellency, the chairperson of the Commission. After that, they give the floor to the Palestinian president, and after they have a group photo, and after this is what is called the open ceremony, and after we are in closed ceremony and we go through the decisions. ministers for 2 days, and sometimes, or maybe all the times, it began very early and finished very late, after midnight. I remember the last year we began at 9 in the morning and we finished 8 in the morning the following day. I was on the podium for maybe 24 hours. Again, question, what is the impact of all our decisions? You can go through the African Union website and you can see the decisions are hundreds of pages. If the question is if the population of Africa understand, knows, have an idea about what we've done during the summit, what are the implications of this decision in the daily life of the Africans? These are questions that can be really challenging. Next, please. So after the Assembly, the Executive Council is the sum of the ministries of foreign affairs or their representatives. So as it is, again, it's a hierarchy. So as I said, after the president, you find the Ministry of Foreign Affairs, and they gather in the Executive Council, and the Executive Council begins 2 days before the summit. And this one also, we finish very late, 3 in the morning, 4 in the morning, and it's a lot to be done. And these are the roles of the Executive Council. But as I said, it's coordinating and deciding on policies in areas of common interest to member states, and it is accountable to the Assembly. So he is preparing the work for the Assembly so that the decision can go smoothly and can be adopted very quickly. But please go ahead. So this is a picture of Executive Council. That means the Ministers of Foreign Affairs. Next slide. And after that, yeah, these are the ministers. After that, the next slide, the most important in all AU are PRC. What is PRC? This is the ambassadors here in Addis Ababa of the 55 member states, because these people are in the dailies policy making. So they are in all the meetings. They are the ones who are taking care about the details. And when it is the PRC meetings, we can spend 3 weeks in it to prepare the summit and the Executive Council session. And itself, the PRC, it is already having subcommittees. As I said, you can go to the next one. It is divided or classified in subcommittees. Next. And these are the 11 subcommittees. So each subcommittee, it has a topic, and in it we have the bureau, and after that we have the selection of the member states, and they do the work, and after they give their reports to the PRC, and after it goes, as I said, like pyramids. So after the reform, the summit or the Assembly session is once a year, only once a year. Before it was twice, and this is very tough and very short, so we do not have time to implement the decision. And it does cost a lot of money. So they switch to one summit a year. However, they can do extraordinary summits. And the Executive Council is twice a year. The PRC is twice a year. But again, we can have extraordinary session when needed. Please, the next. Now, as I said, I told you about the Assembly. Now it's the Commission, because with the Assembly, we have the Commission. The Commission is all the building I'm here in. The Commission are the ones who are dealing with the daily life in the African Union to assist the member states. And the Commission itself, it is in a pyramidal architecture. It is dealt or done in a way that you can find the head. Please, next. The head is the chairperson. This is a former one I told you about, His Excellency Moussa Faki Mohammed from Chad. He was re-elected twice, so he spent 8 years here in African Union as chair. Before him, it was Zuma, it was a woman, and this was the first and the unique time we have a woman at the head of the African Union. Next, February 2025, Office of the Legal Counsel had done the election. We supervised all the election. Next, and you can see here the new elected chairperson of AU Commission, and he's from Djibouti, and His Excellency Yusuf, Muhammad Ali Yusuf. Next, after the chairperson, I said it's like a pyramid. He has after him the DCP, and Her Excellency Mrs. Selma Haddadi from Algeria is the DCP, the current one. And you have here under them, you can find the commissioners. The commissioners are like the super ministers. Each commissioner is elected for 4 years. All the commission is elected for 4 years, and each one has a portfolio. And the different portfolios are just the mirror of our ministries. And these commissioners, they are dealing with the daily life, and they give their reports to, as I said, to the chairperson. And after they have also departments, and they have a lot of activities, but this is a little bit the pyramid of within the commission. And under each commissioner, there is a huge staff, you know. For our office, the Office of the Legal Counsel, we are depending directly from the office of the, how to say, the bureau, the cabinet of the chairperson. Maybe tomorrow I will tell you about the mandate of OLC. Next. So I said we have now only 4, but next 2 commissioners will be elected in the mid-coordination meeting in the next July. I will not be very long here, just go further. So after that, these are what are the roles of the commission. However, here I put 8, and after I put 6, because before the reform it was 8, and after the reform occurred, and I was part of the reform team in 2017. They just tried to fuse, to do the fusion. They merged the different commissioners or the portfolios, and we are now with 6 commissioners. And you have here the commissioners. We have political affairs. This is elected. We have His Excellency Bankole from Nigeria. Infrastructure and energy. This is elected. We have Her Excellency from South Africa. Social affairs. Same. No, social affairs not. Yeah, it's fine. No, I think political and social affairs, they merge. After that, trade, industry, rural economy, not yet. So this will be postponed. We have human resources and science, it merged. You can go the next slide, you can find exactly the new portfolios, how they are now. Yeah, these are the 6 ones. So for agriculture is His Excellency from Eswatini, Musa. After that, trade, not yet. Education, not yet. Infrastructure, Her Excellency from South Africa. Political affairs, His Excellency from Nigeria, Bankole, peace and security. And health, Her Excellency Emma from Ghana. These are the different commissioners, and we are now with 6 commissioners instead of 8. Next. After that, please, next, let's go very quickly. These are the rules, how we do the election, the rotation, gender parity. We are also the unicity of the African Union. It should be exact number of men and women in all the elected organs. And even when they look for shortlisting directors or whatever, all the time they take into consideration the quota of the member states. They take into consideration the sanctions. If you are under sanction, you are not allowed to give a candidature. And most important, and this is very interesting for Africa, for all organs, including the court, that you have balance, you gender balance. And you can find this nowhere in the other organs at the sub-regional how to say, at other continent or other universal organs. Let's go now the next. So after this is the former commissioners, and next these are the newest photo. At the right side are the former commissioners, and at the left side are the new ones who came and they took the oath, and we've done the ceremony, and after that they've done this photo group. So I said that concerning the question of the reform, it's very important to tell you that before, it is only a remote control that give us the names. Yeah, you have just the member states will just put who are the preferred candidate. However, after the panel of eminent and the selection mode, before you go there, and myself, I was a candidate of Tunisia for education, so I saw all the details, how you are selected on very tough conditions. You are not going there as a commissioner. And this is one of the spirit of the reform, that we need the best and the most talented people in Africa to have such ranks of leadership. The only ones who are not selected by the panel are the DCP and the chairperson. And the chairperson candidates go to a dialogue. It is online and everyone can see, the millions of Africans can see and follow. And this is a kind of how to say, it's just to see what is the vision of each candidate and to see who will be the best fitted so that he can be elected. However, for all the commissioners, they have a very, as I said, tough way to be selected, and that's why we are with the reform, with the new tendencies and rules. Next slide. So I will move very quickly to the Pan-African Parliament. When I say Midrand, no one knows where is it. So Midrand is in South Africa. It is between Pretoria. No one, I said, just about at least the people in Tunisia, because I have a lot of lectures on African Union law and practice, and I ask a lot of questions to the students before I give them the information. I tell them, do you know where is the headquarters of the Pan-African Parliament? They even do not know that we have a Pan-African Parliament. When I say Midrand, no one knows where is it. So it's in South Africa, and this is the capital of a lot of other organs of African Union, Inter Alia, Pan-African Parliament. However, we are not such European Union. Our Pan-African Parliament that has not this superpower to legislate for all African Union. For instance, it is just an advisory organ only. So just this is a little bit about the importance of Pan-African Parliament. Next. And they have sessions, they have rules, they have statute, they have elections, and they are, for instance, only doing advisory. They are the advisory organ for the African Union, but they are doing a lot for dissemination and model law and all these issues, and they gather all the elected persons. They choose 5 from each country. So you can multiply 5 by 55 and you have the total number of the Pan-African Parliament. Next. So this is also the reform, try to better and to improve the efficiency of the organs and to give them more power. And one of them, it's at the top of the list, is the Pan-African Parliament, because normally it has to legislate, and we need to have supranational rules for all Africa so that we can compel with control, with the implementation, with sanctions, etc. We are not yet there. This is also a very important challenge that we can discuss during the questions answers. Next. Concerning now the African human rights system, I just will deal with it very quickly. I know it's very difficult. Professor, how many time I have? 2 minutes or less? I don't know. I will go very quickly. Can you give me 5 minutes? I will try to conclude only with the African human rights system, and I will just finish. And tomorrow we can continue on the other organs. What I need to tell you about the African human rights system, if you can go to the Constitutive Act, you can find all these issues on you see in the Constitutive Act on human rights issues. However, in the OAU Convention, no, sorry, in the text of OAU, you see nothing related to human rights. As I said, the priority in that time was not human rights and rule of law. And that's why African Union on OAU, at least at 1981, so this was at least 20 years after the creation of our first organ, they added a charter on African human and people's rights. So the idea of human rights came a little bit late in the 80s. However, it was, if you can compare our charter to other instruments on human rights in the world, especially the inter-American one, the European one, our is better. Why? Because it includes all generations of human rights, and it insists on the people's rights. So the collective rights are very important for Africa, and at the same time in the charter, in the second part of the charter, they put an organ to interpret the charter and to do not only interpretation, but also to protect human rights. It was called the Commission of Banjul, Commission of People and Human Rights. However, I said there will be an evolution. If you can see all the texts coming after that to institute and to create our African Union Court, People's Court. You understand that I told you about the Court of Justice, but I will come back to this idea of Court of Justice. And we have also another protocol on Sharm el-Sheikh to do the fusion of the Court of Justice and the one on human rights. And we have a third protocol, that is Malabo Protocol 2014, to not also to merge, but also to add a section on criminal jurisdiction. I will explain more that after you can see at least the umbrella of the human rights background. It's about the Charter, African Charter of Human and People's Rights. It's a wonderful text. You can go through it and you can see all the comments on it. And this is also a very interesting instrument for the judges of the court to interpret the human rights issues. And they are doing wonderful jurisprudence and case laws in all issues related to human rights, including environment. And you can follow, again, they have a wonderful website. Maybe you can go through the slides. Next one. I can tell you about them more. So I will not go through details. Let's continue. These are all the characteristics of the charter and the human rights in this charter. Please go ahead. Next slide. I told you about the second part of the chart. It's about a committee that is called the Commission of Banjul because its headquarters is in Banjul in Gambia. And the idea of this committee next is its role is triple. The website, you can go there and you can really find and discover wonderful also jurisprudence of the Banjul Commission and the reports and all the interpretation they are doing. They are doing wonderful work. All the organs in general, they are elected members and the component is 11, all the organs. Next. So it is the role of the Banjul Commission that was inaugurated in 1987. It is composed, as I said, of 11 elected members, and they are elected for 6 years term. They have at the beginning 2 sessions a year, and after they updated and they introduced another rules of procedure, and they choose to do 4 sessions a year because human rights issues are more and more important and there is a lot to do, and 2 sessions a year are not sufficient. Next. So also when I speak about human rights in Africa, you can see the deficit of human rights. We have a sort of taboo on human rights, democracy, rules of law. So can you imagine that some of these commissioners who go to state members to do their work, to do reports on human rights issues, depending on their different segments, some are on refugees issues, some are on issues related to democracy, elections. So some are related to torture. So all they are doing is just to do reports. Some of them, and I have friends and colleagues who tell me their own stories, they said, the country said we are persona non grata and they do not give us access and no visa if we need to come back again to report the issues of human rights in this states. Also, sometimes the Banjul Commission is also trying to have the approval of the PRC and all the other organs, political organs on their reports. Some states even ask the Banjul Commission to delete some paragraphs, and some others said, don't put or mention our name of the states on your reports. Can you imagine what they are having as current situation on human rights? But again, if you can go on Banjul Commission website, they're doing wonderful work. Please go ahead. Next slide. Can we go to the African Court? So all these issues, yeah, they are dealing a lot on protection. I said they have 3 things. They do interpretation of the charter, they do protection, and they do promotion of human rights. They do all that together. This is the role of the Commission. However, they do not have any binding decision. That's why in CERT declaration and in the new arena and the new ideas of the 3rd generation of Pan-Africanism, they needed to create a new protocol to have a court. In Inter-America, in Europe, they have their own court of human rights. We are still behind, and that's why, next please, you can see that the next step will be to this. It's about the promotion protective mandate. Go ahead. These are the rules I already sent a few words on that. Let's go to the court. Go ahead, please. Yeah, we are here with the court. The court is in Arusha. Arusha is in Tanzania. And Judge Abdulqawi Yusuf is doing really a lot with this idea of having Arusha as the capital of international law for Africa. And he's also trying with other colleagues, professors like Abdulqawi Yusuf, to initiate this question of international African Union International Law Institute workshops, academia, and I had the pleasure and the honor to do the first one last summer. For the ones I can see, more than 600 people. So the Africans who are interested, please go on the Institute of International Law and try to see what are the programs and see if you are allowed to have for free or to have grants or whatever, or if you have money to come. It is not only for the students, the professors, the practitioners, the judges, the lawyers. It is open to everyone. And it is, again, we spent together 2 or 3 weeks learning on African Union International Law background that really a lot of persons do not know enough. So this is really wonderful. We began with the English sessions, and we will switch also to the French one when we have more money and budget. I said Arusha also is the capital of the Court of African Human People's Rights African Court. And again, they are elected judges, 11 ones, and you have gender equality. And these elected persons are the ones who let's go to the next slides. You can find a lot of details on the election, on the sessions, they have 4 sessions like Banjul Commission, and each session is more than 3 weeks. Please go ahead. You have the mandate, the mission, and the vision. You have, what is here I just highlighted it in bold. Its decisions are final and binding on state parties to the protocol. Only the state parties on the protocol that does instituted this Ouagadougou protocol that created the African Court. For example, Egypt did not ratify this protocol, so they are not, they are not part of it, so they do not have the right or the possibility to send candidatures for judges, elected judges, nor the other states. We have only, I think, 30 states that ratified the protocol establishing the court. And what is interesting here, when I compare the court to the Banjul Commission, is that the decisions are binding. So we are dealing with human rights, and there is a lot of, we are in Africa, you can you can have an idea, maybe you can see the jurisprudence. Let's go further so that you can have an idea. Please go ahead so that you can see. I just tried to put that as theme. Here it's applicable law that said not only the charter, but any other relevant human rights instrument ratified by the states concerned. Go ahead. Just I need to see the different domains on which the African Court is dealing with. Please go ahead. The president of the court is the only one who is permanent in Arusha. All the others are not permanent. I put here some challenges, but you know all of them. It's about, go ahead. I just put more details with the problem number 1 is the low rate of ratification of the protocol. Problem number 2 is the access of the court by individuals. Just ask questions to your neighbors, to the people you know in your family. If you have last resort, last jurisdiction in your national court, are you allowed to go further in a supranational jurisdiction? I'm sure that no one knows about Arusha and the court, and you are allowed, if you are not satisfied with your judgment, to go to the court and to appeal. And this is really something very interesting, because we have this article, after that. There is an article 34, paragraph 6, that gives you the opportunity to go to the court directly as individuals, but the condition is that your state ratify this article. So the promotion of the court among Africans, I think there is a lot to be done. There is not enough dissemination of the court, its jurisprudence, and its role. Also the non-compliance or slow compliance with the court's decision. When I say binding, this is theoretical, because you can go to the website of the court. They are the ones who do statistics, and they are the ones who say 90% of our cases are not implemented. Can you understand? 90%. And this is exactly the opposite from European Court. European Court of Human Human Rights, it's just the opposite. More than 90% of the decisions are applied and implemented. We have exactly the opposite in Africa, and it's a pity, because if All the work is done. However, at the last resort, nothing is implemented, or slow implementation, or the states just withdraw themselves from the articles or even from the protocol. It's a pity. That means that we do not believe yet in our organs, and we do not have the political will to implement the decisions of any organs who control the system. Next, please. I just try to put some themes on the different jurisprudence of the court, from the right to participate freely in the government, the question of the freedom of association, freedom of speech, the right not to be discriminated. And I put here some of the cases, but as I said, you can go through it, and you go to the website, and you can find in all AU languages all the jurisprudence of the court: French, English, Arabic, Portuguese, Spanish, and Kiswahili. Next, please. Or I just tried to put some thematics so that you can see how the evolution of the cases and the court on its jurisprudence. And I'm sure, again, that a lot of our people do not know about this jurisprudence. And you can see that normally, if we respect our organs, our judges, who are, in general, I speak for Francophone states, they do not have the common law background. So for them, they are private law background, and they do not have a lot of knowledge from international perspective, regional law perspective. So it's a pity that they do not put this, what I said, landmark decision, you know, from the court, from African court. And this is really a pity, at least in the side where I'm living, Tunisia and the north of Africa, because we ignore totally all these jurisprudence, and each of them it's a course by itself and a lecture by itself. Next, please. So I said that it covers freedom of expression, environment, liberty, security of the person, a lot of wonderful things, nationality, etc. Next, please. Next slide. I put a question mark on the Court of Justice and Human Rights. This is the fusion. Let's go, please, in the slide where I just, go. I need you to see the overall view. I put here all of them, just put all of them, all these protocols. So the Court of Justice, I show you the Article 5 of the Constitutive Act, where the Court of Justice is there. However, it is, as I said, it did never see the light. So it was not born till now. What they tried to do after that, 1998, as I said, this is the Protocol of Ouagadougou, to establish an African Court of Human and People's Rights. And after that, they said, because we do not have enough budget and not enough human resources, let's merge the Court of Justice and the Court of Human and People's Rights. And this was the Sharm el-Sheikh Protocol 2008. This is to merge the two courts. However, this protocol didn't enter into force since 2008. After that, what they've done is to add another protocol. This is the Malabo Protocol 2014, not only to reinforce the idea of to merge the two African courts, but to add a new component, and this component is called the criminal section, you see. And this international criminal law section, you can find more than 14 crimes, international crimes. So the crimes you know about is about crimes against humanity, the crime of genocide, the crimes of war, and they added more than other 10 crimes, including terrorism, including slavery, including fighting there is questions on environment, questions on blanchiment d'argent, bank. Anyways, so there you can go to the Malabo Protocol and discover more. Go back, please. This Peace and Security Council maybe tomorrow. I just need to finish this idea to give you just an overview of the very difficult and challenging constitution of our organs. Do you know how many member states ratified Malabo Protocol? We are in 2025, so it is at least 10 years. In 10 years, only one ratification, it was Angola, only one. So on the basis of this, we need 15 ratification. If we need 10 years for one ratification, that means in 100 years, we will never see this merged court plus the section on criminal issues. So why the criminal issues? It is about the context. In 2014, do you remember the case of the case of Kenyatta of Kenya and the case of Omar al-Bashir? The ICC, the International Court of Justice, the Criminal Court, International Criminal Court, at that time, the Africans said, why they are focusing only on Africa? So we need to do something regional at the continental level, and that's how they imagine the section of international crime law. However, they added, and they put it here in red, an article that is really very challenging, and I think I just in AUCL I've done a lot of studies, and I've done a study on the immunity in international law, and this is about immunity. Article 14.6a bis give immunity to the member states and other officials, other political high officials, in case of international crimes. So for me, this is like verrouillage. You are just doing the thing, and you are at the same time blocking it. So how you give immunity to these people who've done international crimes? These are erga omnes obligations, and they have no exceptions, erga omnes rules, etc. So this is a pity that we are still with this rule 46a bis that gives the impunity to the heads of states in case of international crimes. And that's why there is two ideas. Let's go to the fusion and to merge all of them and to create our own international courts at the African Union level. Another idea said, no, we are not still yet, we are not yet prepared to tackle these issues. We need just to begin the reform and to take time to see the implication, financial implication, legal implication, and to see it's a whole construction. So it is not just elect and that's all. I remember in the summit, February, there was the report on reform. So every year there is the president before Ruto. This year it is President Ruto from Kenya, who is the champion of the reform. Before that, it was the president of Rwanda, Kagame. So when they came with their reports, they put a lot of ideas in order to push all this construction of African Union organs, to reinforce them, to strengthen them, to begin something, including this year. The decision was to elect, the initial draft was to elect 11 judges and to operationalize the African Court of Justice. However, the drafting committee had done a lot of work on the basis of the ruling of the chairperson, and they said we are not yet there, and they give the mandate to the commission through the OLC to do the implication, legal, financial, institutional implication of the court on the operationalization of the Court of Justice. And this was the idea, let's operationalize at least the Court of Justice, and the two other protocols can wait because they are not entering into force yet. However, the one on the Court of Justice is already entering into force. However, we never saw the Court of Justice. You can see now the Court of Justice and how many jurisdiction or disputes on African countries is pending in front of ICJ. So the idea why we do not have ours, we have our experts, we have our legal experts, our own judges, we can manage. These are what is called the African solutions to African problems. However, again and again, this is what I need to all the time put on the table. Political will is not yet there. There is a lot of challenges in such operationalization of such court. And more than that, I think the construction of integration needs time, needs a lot to be done before going to organs. We cannot just impose these organs. I gave you statistics. I gave you how many states are sowing and seeing and believing in our organs. I think we need to do much more so that we can rely this gap between the practice and the institution. Here, this is my casquette of the researcher, the professor. When I give my lectures to my students, I tell them, ask questions, give opinions, give recommendations, how we can deal with these issues. We have a lot of challenges. We do not need to be blind on them. Let's just focus on them. Let's try to see how we can tackle them. You are, as you are now, the young people, the future people who decide. You will be the leaders of Africa. So this is also your responsibility and your duty to make some change, and the change will come. I'm all the time optimistic, and I think this is exactly what we are doing here in gathering ourselves in African law seminar in such how to say initiatives. This is exactly what we are trying to do, is to push, is to recommend, is to do how we can tackle all these challenges together with the right way. Maybe tomorrow I will go through the Peace and Security Council, the question of the conflicts in Africa, silencing the guns. We are really champions in slogans. However, when it is about reality, you can see Sudan case, you can see RDC, you can see a lot of misery in our countries. So what is the impact of all this? What is our principles? I show you the Article 4, where there are the principles of peaceful dispute, of settlement, of non-interference, non-use of force. However, the practice is another thing. We can also tackle other organs, and we can see on the paper we have the institutional financial issues. However, we never saw them, and maybe I will put the stress on some other original instruments so that you can at least have a general idea on them. I will just finish here, and maybe tomorrow I can go more on details, but I need to hear from you. If you have any questions in the chat, I will be very honored and to share some responses. Thank you so much, and I'm sorry, I think I spent 1 hour, not half an hour. Thank you so much. The floor is yours.
Hajer, that was amazing. There are very few people in the world who could have given that lecture. It is a clear reflection of your commitment to the goals of the African Union, to Africa. The slides were amazing. You almost made it. I think we can continue tomorrow. I already have requests to continue this seminar. I think that for me anyway, I have learned so much, and I think it is extremely worthwhile. And I think that this is just the beginning. You can expect an email soon about dates for the second seminar, but it was truly extraordinary. And this introduction will, of course, provide the essential foundation for your focus on specific areas of African Union law tomorrow. I noted the 4 that you highlighted. These are extremely important. So with your kind permission, I would suggest that we give the floor to Judge Yusuf, and then we carry over tomorrow, and you can have a chance to look at the questions. You may choose to answer those that you wish, and then we'll continue with your full lecture, and we will have 2 hours tomorrow. It will not be enough, but we will make more progress. Thank you. That was amazing. So, turning now to our second distinguished lecturer. I have worked closely with Judge Yusuf and the African Institute to promote the teaching and dissemination of international law for the benefit of Africa for more than a decade. Judge Yusuf recorded lectures for the AVL and attended every regional course that I conducted in Ethiopia. I attended the meeting of the African Foundation of International Law in Mozambique in 2012, which led to the creation of the African Institute of International Law. I fully support the work of the African Institute, which is uniquely qualified to provide the international law training needed for the development of Africa and the achievement of the goals of the African Union. In 2016, I worked with the African Institute to conduct the first international law seminar for African universities in Ghana under the UN Program of Assistance, to provide training to enable faculty members to teach more courses on international law and African Union law. Unfortunately, this seminar has not been held since my retirement in 2017. I have been working with the African Group of Legal Advisors at the United Nations in New York to gain support for resuming this seminar, hopefully on an annual basis. In the meantime, the African Law Seminar was initiated to help fill the training gap by providing international law and AU law education to law schools throughout Africa. More than 50 law schools in 30 African countries in all 5 regions registered to attend the seminar. It is now my pleasure to introduce Judge Abdulqawi Yusuf, who has served as a judge of the International Court of Justice since 2009 and is vice president and president of the court. Judge Yusuf has had a distinguished career as a jurist, diplomat, and legal advisor to various international organizations. He is the author of numerous books and articles on a broad range of topics of international law that are of particular importance for Africa. He is the founder of the African Yearbook of International Law, the African Foundation for International Law, and the African Institute of International Law, under the auspices of which this seminar is being conducted in cooperation with the African Union. Judge Yusuf has taught and lectured at universities around the world, beginning with the Somali National University. Judge Yusuf, you have the floor.
So I'm really happy to participate in this webinar, and I would first of all like to thank Virginia Morris for taking the initiative. She has been committed for a very, very long time to the dissemination of international law in Africa and to training and education on international law in African countries and to African lawyers and students. She was with us at the ceremony for the inauguration of the African Institute of International Law in Arusha exactly 10 years ago in 2015. And she has accompanied us in all our efforts to bring the Institute to reality. Since then, she has also been supporting all the efforts of the Institute. And the Institute has actually two main functions. One is education and training, which is held at the headquarters of the Institute. And the second one is to create a network of affiliated law schools throughout Africa, in which the Institute, in cooperation with others, can engage in capacity building. And this is exactly what Virginia is doing now. She has brought to life that network of African law schools, and she is already engaged in the capacity building. And this webinar is one of those actually efforts of capacity building for students at law schools in Africa. And I'm very happy that there is such a wide participation in this webinar. And I hope that we can organize similar webinars in the future. And I hope that we will also find other ways of developing the capacity of the law schools throughout the African continent, because what we lack in Africa, above all, is skills in international law. We also lack knowledge and familiarity with the law of the African Union and the public law of Africa. The African countries have been giving themselves and building since the 1960s a legal system which is most appropriate for African countries and for intra-African relations. And that system now has more than 58 conventions, treaties, protocols. But I'm quite sure that none of these instruments is taught in your schools, and that you are not acquainted and you don't have an opportunity to get acquainted with all those instruments. So I was so happy to listen to the lecture of Professor Hajer Gueldich. And I am very happy that she actually preceded me, because she gave you the historical development, all the historical background of the building, the construction, the creation of the African Union, the organization of African unity, the law of the African Union, and how the African Union functions and works every day. So I don't have to repeat those things in my intervention now. I will just limit myself to a brief presentation of the relationship between the public law of Africa and international law. And let us start with the public law of Africa, because what do we mean by the public law of Africa? Professor Gueldich spoke to you about the law of the African Union. That is the law which relates to the organs, to the functioning, to the charter, constituent instrument of the African Union, and how the union operates. The public law of Africa is much wider. It's not only about the African Union, it is also the legal norms, principles, and rules which are common to all African states and to which they have multilaterally and collectively committed themselves. Professor Gueldich mentioned it, for example, the African Charter on Human and People's Rights. That is part of the public law of Africa. It is an instrument which belongs to the public law of Africa. The Maputo Protocol on Women's Rights is an instrument which belongs to the public law of Africa. The Kampala Convention on Displaced Persons is an instrument which belongs to the public law of Africa. The Arusha Convention on Refugees is an instrument which belongs to the public law of Africa. And so the public law of Africa is a regional law of African countries. It is the regional international law of Africa. And it is a law which regulates the relations among African countries, but at the same time, which recognizes certain norms, principles of international law, not only within Africa, but actually goes very often beyond those norms, rules, and principles of international law. Because the African approach is not necessarily identical to the universal approach. International law is of a universal character since the adoption of the Charter of the United Nations. We did not have international law before that because we had regional laws like the one I'm talking about in Africa. There was a European public law. There were, of course, African usages, African inter-African treaties, African customary laws. There were similar laws in Asia, etc. But of course, most of the time, when you hear about international law in the 19th century or in the early 20th century, people are talking about the public law of Europe at the time, a law which was applied only among European countries, and a law which actually was restricted by the European powers themselves to their relations, because they said that the law applied only to what they call it civilized nations. And so there was this self-styled club of so-called civilized nations, which actually decided who could be admitted to the club. So they created notions such as constitutive recognition. So you would be a state only if you were recognized by the European so-called civilized club. Otherwise, you would not be a state, and therefore the public law of Europe would not apply to you. So it was also a law which facilitated and enabled those European powers to colonize Asian and African countries. Because when you say you are not a state unless I recognize you as a state, then you may be colonized by other states because you are nothing. You don't have any rights. You don't have any duties at the international level. And that's why they always refer it to the tribes in Africa that did not have a legal personality under international law. And they say that those tribes did not have the qualities and characteristics of a state because they denied the self-government of African nations, that African nations governed themselves in their own way. And they would not, of course, be willing to recognize them. So there was this notion of constitutive recognition. You are a state only if I recognize it. And then they use it another notion, which you still find in certain books of international law, which is called territorium nullius. Literally, territorium nullius means a territory in which there are no inhabitants. But no, they did not mean by that. In Latin, that's what it would mean. But what they meant was that there were inhabitants, but they had no government, they had no state. And therefore, we were allowed by our law, which they sometimes refer to as international law, to take over such territories, to occupy them. Sometimes they would refer to them as territories that are inhabited by barbarians and savages. And of course, the law would not apply to barbarians and savages in their view. And therefore, you needed to be only a civilized country with a state, with a government recognized by the concert of Europe to be part of international law. And that's how colonization was legitimized, legalized in their eyes. So the first call at the international level for a legal right to self-determination and self-government was by the Pan-African Congress held in London in 1900. And you have to know that even after the Charter of the United Nations was adopted, which contains the principle of equal rights and self-determination of peoples, which is a basic principle of international law today, of the universal international law, because I'm now talking about universal international law. Even after the adoption of the Charter, many European publicists and scholars continued to say that this was just a principle and there was no right to self-determination. Because a right of people is to self-determination would go against certain concepts, notions, and principles of the public law of Europe to which I referred earlier. It would go against the concept of colonizing and occupying the territory of another state. And of course, taking over the government of a people who did not consent to such a takeover. So it is with the admission to the United Nations in 1960 of newly independent African states that the United Nations, for the first time, proclaimed loudly and clearly in Resolution 1514 that this was not only a principle, the principle of equal rights and self-determination of peoples in the Charter of the United Nations, but that it was a right to self-determination. And in the same resolution, the United Nations General Assembly outlawed colonialism and colonial occupation and domination of peoples without their consent. Of course, nobody would consent to be colonized. So colonialism was for the first time in international law outlawed by the law. And of course, recently in the Chagos Islands advisory opinion by the International Court of Justice, the International Court of Justice said that this resolution reflected already in 1960 customary international law and the opinion, juris, and the opinion and practice of the majority of states in the world. Because when the General Assembly of the United Nations voted on that resolution, there was not a single objection to it. There were abstentions, and the colonial powers abstained, but they did not and could not object to it. The world had changed. And the fight for self-determination, which the Pan-African movement started in 1900. And Professor Gueldich spoke to you about the London meetings, the Manchester meetings. They were always outside Africa. They were repatriated and brought to Africa only with the independence of Ghana and Guinea. And then they were held, the Pan-African Congresses were held for the first time on African soil in 1958. But before that, the right to self-determination and the human rights of peoples were battles, fights, efforts undertaken by Pan-Africanism and by the Pan-African movement, both inside Africa and outside Africa. And that is why you see, and this is where I was coming, what I was coming to. That's why you see in the African Charter on Human and People's Rights, you don't have only human rights, you also have people's rights. There is no other human rights charter which has codified and included amongst its provisions collective rights for peoples. And this is based on African tradition, African custom, and the fight of Pan-Africanism for people's rights since the early 20th century. You also have, and this is something that is not codified anywhere in international law, in universal international law, a right of peoples to development. Of course, the United Nations has adopted several resolutions referring to the right to development. The United Nations Council on Human Rights talks all the time about the right of peoples to development. But there is no hard and binding international legal instrument on the right of peoples to development except the African Charter on Human and People's Rights. And that is part of the public law of Africa, but it goes beyond the universal international law. Another right, which is recognized in the Charter, Human and People's Rights Charter of the African Union, is the right to a clean environment. The United Nations General Assembly and many states around the world have been and are still fighting for the recognition of this right at the universal international level and in its inclusion in a binding instrument similar to the African Charter on Human and People's Rights, a binding treaty or convention, which is binding on states. but they have not succeeded up to now. However, the United Nations General Assembly has adopted a resolution. Of course, the resolutions of the UN General Assembly are recommendations. They are not binding instruments. But when the majority of the 193 member states adopt a resolution, and there are no objections to such resolution, then of course, such a resolution expresses the opinion juris of the international community, the conviction of the international community and of the member states of the UN General Assembly that such a norm, such a rule, such a right belongs to customary international law. And I personally believe that although the African states started to include in their charter the right of peoples to a clean environment, to a clean and healthy environment, that right has now become part of customary international law. But it is a right which did not exist before at the universal level. So these rights, which are collective rights, are found in the African Charter. They are people's rights, but many of them are not or have not been included in binding instruments at the universal level or have not yet become part of customary international law. So in that sense, the African Charter is much more advanced than the universal norms and principles on people's rights. However, one has to add, unfortunately, that although these rights have been recognized by all African states, and although they have included them in their charter, they do not always live up to the expectations attached to those rights. And it is extremely important as African jurists for you to stand up for what states African governments have recognized and committed themselves to respect and to observe and to make sure that these rights are enforced and respected and implemented in the domestic legal orders of your countries. They have to be implemented in the domestic legal order. And in many cases, that is what is missing. They have to be reflected in your constitutions and in your laws, because you cannot subscribe to an international binding instrument and just forget about it. You have to implement it. You have to enforce it. You have to live up to your legal undertakings, which are binding on you. Another example of the public law of Africa, which of course goes beyond the universal international law, is the Kampala Convention, for example, on displaced persons. The universal legal order recognizes and is familiar with the concept of refugees. The United Nations 1951 Convention on Refugees codified the principles, norms, and rules related to the status of refugees. It defined what's meant by refugees. And Refugees, of course, in order to be recognized as refugees, they have to cross the borders of other states. But displaced persons do not necessarily have to cross the border of a state, of another state, of a foreign state. But they are refugees within their own countries. They can no longer stay safely and peacefully live in the areas in which they live because of an internal conflict, or because of drought, or because of other man-made or natural disasters. And therefore they have to move. And as a result, they lose their homes, they lose their homesteads, they lose their livelihoods. And they have difficulty coping with the new situation. It's a humanitarian disaster. And it's a humanitarian disaster which you find in most African countries. And that is why the African countries were the first at the international level to adopt such a convention, a binding instrument relating to displaced persons. It is now in force. But the question is, again, do they live up to it? I hope you can verify that by yourselves. And I hope that you will make sure that African states live up to their undertakings also, because it's not enough to claim that you adopt international instruments which are more generous, more humane, and which recognize more our solidarity as human beings, and then set them aside. No. If that solidarity is to be really recognized, then the provisions of the convention have to be implemented. And they have to be implemented in the internal legal order of the country. And that is what we need to see. A third example that I can give you is actually the Arusha Convention on Refugees. Because the 1951 United Nations Convention on Refugees was based on the concept of individual persecution. You had to prove and to show that you were personally, or if you are with your family, you and your family were persecuted in the country from which you ran away in order to be eligible for asylum. And that's what the 1951 Convention says. But because of what was happening in African countries in the 1960s, because all the African countries in the 1960s did not become independent. Some of them were still under colonial yoke. Others were under the domination of minority racist regimes. South Africa and Zimbabwe were the most outstanding examples of domination by minority racist regimes, which were, of course, helping from outside to continue that domination. And so there were people from those countries, South Africa, Zimbabwe. There were also people whose countries were still under colonial occupation. Mozambique, Angola in the 60s, especially early 60s, Mozambique, Angola, Cape Verde, Guinea-Bissau, all the Portuguese colonies were still under colonial occupation, and the African countries, the independent African countries, had to help them overthrow that colonial occupation and acquire their independence and freedom. But in the meantime, people had to leave those territories. And it's not because they were individually persecuted. No, they were not individually persecuted, but they were collectively being punished by the colonial powers because they stood up and asked for their freedom, for their independence. And they were being punished for that, so they had to run away for their lives. And they were, of course, welcomed by other African states, but there was no legal framework under which their benefits, their recognition, their status could be determined. And that is why a new legal regime regarding refugees had to be elaborated by the African states under the auspices of the Organization of African Unity. And that legal regime of the Arusha Convention is much more generous, much more humane, much more solidaire in the sense of expressing solidarity among African states, among the peoples of Africa, than the Universal Convention on Refugees. But these are not, of course, the only examples, but I thought I should give you, at least because of our limited time, a few examples of what we mean when we say that there are commonalities, but there are also differences between the public law of Africa and universal international law. Of course, African states recognize and observe and respect the instruments of universal international law, but they had to adopt their own instruments also in order to take care legally to deal with in a legal, juridical way with the needs and with the typical or peculiarities, particular conditions, the particular conditions of their own populations. Because what is the function of law? The function of law is to reflect and to address the needs and particular conditions of a society and the needs and the conditions of African societies are not necessarily the same and cannot necessarily be translated into law in the same way that the needs and conditions of the international community as a whole are regulated by law, by universal principles and norms of international law. So it is important that these rules and principles that have been laid down through conventions, through protocols, through treaties, promoted and sponsored by the Organization of African Unity and by the African Union, it's important that they should be translated, adopted, and integrated into the domestic legal fabric of African states. And it is only through education, through dissemination, through familiarization with these instruments, that this will happen. And that's why it is important that the African Union itself, in my view, should engage in outreach activities amongst its member states, and of course, in the universities of its member states, in order to spread the message, to spread the word, to talk to them all about the need for integrating this intra-African instruments, intra-African law, intra-African public rules and principles into the domestic law of African states. African states are still having a lot of difficulty integrating those instruments into their national laws. And that is also a task that should be facilitated by the African Union itself, because African states are still divided along colonial lines. There are those African states who still use civil law approaches and therefore have a different way of integrating international legal instruments into their domestic law than other African states who have adopted and inherited common law approaches or common law traditions from their colonial, from the colonial powers which occupied their countries over hundreds of years. But those approaches may continue to be different as far as international universal legal instruments are concerned. But as far as African legal instruments are concerned, it is a task, and it should be the mission of the African Union itself to harmonize the approaches for domesticating and adopting in the domestic legal order the public law of Africa. And therefore, the public law of Africa does not need to be domesticated within domestic African legal orders in the same way that international universal legal instruments are domesticated. A different approach needs to be adopted. And that different approach should be a unified and harmonized approach. It should not be a different approach, whether you are French-speaking, English-speaking, Portuguese-speaking, or Arabic-speaking. No, absolutely no. It should not be. It should be a harmonized and universal and unified African approach to adopt the laws of Africa. These are the laws of Africa, and they were adopted because African leaders, African peoples felt that they needed them. And how can you treat them in the same way as norms and principles and rules which are needed for international relations and which govern your relations with countries outside your continent, because there are certain shared needs. They're different and they should not be treated in the same way. But there are also difficulties because maybe the values which are reflected in some of these instruments have not yet found acceptance in certain African societies, although they were actually meant to translate into legal terms those values which were shared by African societies. And I will give you an example. There is an African convention which is in force, which outlaws coup d'etat or unconstitutional governments that come to power through force, through military means, through the use of violence sometimes, not revolutionary violence, which is a different matter, but military imposition by force of a regime on the people of a country. And this is what has been outlawed in that convention. And it has been accepted by a lot of African states. But you see that coup d'etats are still taking place in Africa. And the only way the African Union deals with these things is to impose sanctions and exclude those states, suspend them from the African Union. That's not a good remedy. And especially when regional organizations like the ECOWAS impose sanctions on poor, least developed African countries because there was a coup d'etat in the country. The people who suffer most from those sanctions are the ordinary people of the country. They are not the elitists or the elite or the military elite who took over power. They are not absolutely touched by the sanctions. So what are you sanctioning? What kind of remedy is that? That's not a legal remedy. What the African Union and the regional African organizations like the ECOWAS need to find is a legal appropriate remedy, which does not punish the people on whom the regime was imposing, but which helps the people. And also helps guide those who had unconstitutionally and illegally overthrown their own governments, helps them guide back to the will of the people, to a governance that is based on the will of the people, and which reflects that will. So this is also another problem as far as the domestication, implementation, and enforcement of the public law of Africa is concerned. Because, for example, coup d'etats are not illegal under universal international law. If a coup d'etat takes place somewhere in the world except Africa, the United Nations Security Council does not come out and condemn it, because governments may change sometimes in an unconstitutional way, and they have been happening in Latin America for ages. But the African states decided that coup d'etats should be outlawed because they were not helpful to the welfare, to the well-being, and to the development, economic and social development of African peoples. And therefore, they decided that they should not be considered legal in the African legal order, in the public law of Africa. And they have adopted a legally binding instrument which is different from the universal norms concerning coup d'etats in member states of the United Nations. But adoption is not enough. Implementation is required. And I think I will stop here, and with those examples, take time to take your questions and answer them. And of course, if there are certain matters which I have not addressed in my brief intervention, you can raise them and I will address them in answering your questions. And Virginia, over to you. And thank you.
Thank you, Judge Yusuf, for that very enlightening, powerful, inspiring lecture, as always. We are running a little behind schedule today. There are some questions in the question box. Do you want to try to take one question or?
Yeah, one or two quickly, and then we wrap it up.
Okay, great. And the other thing I was going to mention is that, as you know, this first African law seminar was a pilot project to determine the feasibility and the practical value. I think that the response from law schools across Africa has demonstrated that this is a worthwhile endeavor. So at the conclusion of this first session of the first African law seminar, I will be sending an email to the academic leadership and faculty members who have expressed an interest and asking them to provide information about their academic calendars. It is challenging not only to figure out the time zones, but to figure out when we can do this again. And I'm thinking about, just to give you an advance notice, because I will be asking you about continuing this after the well-deserved summer break, perhaps in September. And I think there is so much information to cover. This is clear from your lecture. It is clear from Hajer's lecture. I think it's a fantastic beginning, but it is just that, the beginning. So let me see. I did see one question that was addressed to you. They were asking about the difference between public international law and the public law of Africa.
That is actually what I tried to address, because the public law of Africa is the law that is limited only to African states, and therefore it does not apply outside Africa. That is what we mean by public law of Africa. It is an intra-African law. It is, let us say, regional international law, an interstate system of norms, rules, and principles which is applicable only among the African states. Public international law is what we know as the universal rules, principles, and norms which regulate relations among all the nations of the world, and which are recognized by all of them, and which have to be respected by all of them. And so that is international law generally, public international law. The public law of Africa is the intra-African aspect of it, which applies only among African states. That is a brief description of the difference. Thank you.
Well, there is another question that is probably on the minds of many people watching this today. Some of the young people would like to know, how could they possibly wind up at the International Court of Justice someday?
By studying, by working hard, by competing, by being able to compete at the international level with people who have your background and your skills in the law, but you will have to do better than them in order to become eligible to be elected to the International Court of Justice, of course, because there are 8 billion people on this planet, and there are hundreds of millions of people who would like to sit on the bench of the International Court of Justice, and you will have to prove that you are better than most of them, and therefore to show to the world, because it's one of the most difficult elections in the world, you have to have the confidence and the approval and the support of both 193 states of the General Assembly, the majority of those states, and also the majority of the states members of the Security Council. It is when you have both of them that you can become a judge of the International Court of Justice.
One quick follow-up question, if I may. What about the younger people? Are there any fellowships available for promising?
Yes, actually. And while I was a president of the court, of the International Court of Justice, I realized that most of the judicial fellows that the court had were sponsored by wealthy universities in the North, in Europe, the United States, Australia, and Canada. And therefore, I decided to establish, together with the Secretary General of the United Nations, a judicial fellowship program for students from the global South. And we established a trust fund in the United Nations. And through that trust fund, I am extremely happy and proud to say that every year we take 4 judicial fellows from the global South, and that last year, 2 of those judicial fellows were from Africa. One was from Eritrea, and they are still at the court, and the other one was from Kenya. And we have been doing that for the past 5 years. And we will continue to do that because we have enough money in the trust fund in order to sponsor students from African universities who have an advanced university degree in law. That is at least a master's degree in law.
I think just 2 more questions, and I appreciate the patience of everyone. There is a request for a link so that the participants can know how to apply for this fellowship. I assume that I can provide that. I'll follow up with your office on that. And one last question. There's so many good questions. I regret we don't have time to answer them all. Hajer will be able to answer many of these tomorrow that address her topic. One of the participants is asking, what is the difference between the public law of Africa and the law of the regional organizations within Africa?
Mm-hmm. The law of the regional organizations is a subset of the public law of Africa. It is a subset, it is a subsystem. The larger system is the public law of Africa, which actually comes under the continental organization and which is sponsored and promoted by the continental organization, whether this was the Organization of African Unity or the African Union. But we have the sub-regional. And the sub-regional organizations do not usually have public instruments which are ratified by all the member states except the law of the regional organization, the law of the ECOWAS, the law of the East African Community, the law of IGAD. Those are their charters, but they don't have instruments on human rights, instruments on displaced persons, instruments on women's rights, instruments on governance and good governance and democratic, etc. But even if they had, that would be a subsystem, and a subsystem cannot be in conflict. It could go further and therefore give more rights, but it should not be in conflict with the higher system, which is the public law of Africa. And therefore, the 2 systems will have to be reconcilable.
Thank you so much. I'm so sorry we don't have time to answer the rest of the questions. Perhaps I'll figure out a way to follow up with you. And I look forward to inviting you back to the 2nd African Law Seminar. I will follow up with you. Thank you.
No problem.
That would be wonderful.
You know that you will have all my support for that. Thank you.
You have always said yes whenever asked.
Yes,
so
yes.
I thank everyone and wish you all a good evening. And I look forward to following up with you tomorrow with Hajer. Thank you so much. Good night.